Okay, seamless. I'm sure I'll get better at this as we go on. Right, the next presentation is a little bit more of a kind of detailed look of the regulation. So before I start, I just wanted to make the point really that, you know, at this point we can kind of talk about the EU and the UKTR sort of interchangeably in terms of the requirements of the regulations. So, you know, while this presentation, sort of, I'm trying to speak generically, just, you know, calling it the timber regulations, but I do mean the UK and the EU ones, where the application of the regulation might differ slightly in terms of scope or FLEGT or anything like that. We'll signpost that as we go. But yeah, generally speaking, the requirements themselves are the same. So we're going to look at the who's involved with its implementation and product scope, and then we're going to look a little bit at what we mean when we say due diligence, and then finally enforcement of the regulations to date. So actors and their responsibilities. So you hear us talking about the EU. What we really mean is the European Commission, and so post-Brexit, you know, where it's the UK government that's sort of assuming that role for the UK. Then we have member states and competent authorities within those member states, have monitoring organisations, and then we have the industry themselves, which consists of operators and traders. So we're going to look specifically at member states and the competent authorities. So member states, you know, are legally obliged to implement the regulations, but then within their countries, they detail the penalties within their own legislation. So penalties do vary state to state. They are responsible for designating competent authorities who are then the ones that enforce the regulation. There must be at least one competent authority per member state, but in some countries there's quite a few. For example, Spain and Germany, they have a number of different competent authorities. Within the UK, we just have the one. Member states have an obligation to cooperate with each other and the administrative authorities of third countries and with the EU Commission as far as the regulation is concerned. And they are also required to send a report to the Commission every 2 years on their enforcement activities in their country. The competent authorities are what we call the organisation responsible for the implementation of the regulation by industry. So the competent authorities conduct checks on operators. In theory, they can also conduct checks on traders, but I don't know of a case of when that's happened. Specifically for traders, I think they just focus on operators. Although having said that, operators can be traders at the same time. They have an obligation to keep records of checks that they make on operators. They also have make checks on monitoring organisations operating within their country, and they are responsible for issuing notices of remedial action and initiating seizures of goods or prosecutions where they arise. And They may also provide assistance and guidance to operators, including disseminating of relevant information and organising information webinars and such things. Right. Now we'll look at the requirements of for operators and traders and the definitions of these two groups. So an operator is the organisation who first places timber or timber products on the market being the EU market or the UK market. I'll come back to what the definition of first place means in a couple of slides' time. And then traders are all other businesses involved between the operator and the end consumer. So there can be multiple traders in the supply chain. And like I said, a company can both be an operator and trader, depending on their, what they're importing from where. So what are the obligations for operators? Well, first of all, they are prohibited from placing illegally harvested timber on illegally harvested timber or timber products on the market. They are required to exercise due diligence, and they are required to maintain and regularly evaluate their due diligence system. So the obligations for traders really kind of relate to the maintaining the traceability of these supply chains. So there aren't due diligence requirements, but they are required to be able to identify who has supplied them timber and who the buyers of that timber or timber products are. So for the most part, those requirements are fulfilled through sort of ordinary ways of doing business, but they do need to keep those records for at least 5 years and be able to provide them to competent authorities should they be asked. So who is the operator? So this first placing term, placing on the market is when the material or timber comes into the EU through the course of a commercial activity that must be physically located. So it's not necessarily a financial transaction. Is outside of financial transactions, and you can also be an operator if you place domestically grown EU timber on the market. So it's not just related to imports, but I think for the vast majority of you on this call, it's the first that affects you is the importing of timber. So for importers, how do you know if you're the operator? Well, it's the organisation or entity who is acting as the importer when the timber is cleared by customs, and that is independent of ownership or other contractual arrangements. So in most cases, the importer is the name of the organisation under box 8 of a single administrative document, or the consignee highlighted in red there. So if you're not clear whether you're the operator, you need to seek out this document and see whose name appears in box 8. Identifying the operator where the timber is domestic, harvested and within the EU, it's the entity that distributes or uses the timber when it has been harvested. It can be a little bit complicated to know this relationship or know who's the operator, and you sort of need to know the commercial relationship at the point of harvest. I've given two scenarios there, which I'll let you look at in your own time. You now have the slides, and these two scenarios are taken straight from the EC's guidance document, and there's a link there for you to follow that helps you identify who the operator is. And this is just a diagram summing it up. So the operator there in red can be an operator for domestically grown and harvested timber in the EU, and I should say, and the UK. So that also that domestically harvested bit of the regulation applies to the UK as well. And then also the operator is the ones importing outside the EU, now including the UK, and for UK operators it's anything outside of the UK. Right, so now we're going to look at what's covered within the regulation in terms of products. The scope of the UK and the EUTR is the same. There's no change there. There's a wide variety of products covered, covering paper, cardboard, wood fibre, a lot of the things that you would expect, but you can see the full list in the annex of the regulation. What's covered and isn't covered is based on custom codes. It says EU custom codes there, but really it's HS custom codes, and they're kind of an international standard code system, so it doesn't differ depending on whether you're looking at the UK or EUTR. There are some exceptions to what's covered. Waste products, so recycled products, are out of scope.
We don't see the next slide, only product scope slide.
Ah, okay.
There we go.
Yeah, okay. Yeah, so waste products aren't included, but then there's also, which perhaps you would expect, but then there's some unusual exclusions. So printed material, musical instruments, which perhaps is a surprise to some that it's excluded. But the scope is under review, so there's a likelihood that that might change, but the timeline of that is not clear. So now we're going to look at the term due diligence. So what is due diligence? Well, the EC has issued some guidance around what they mean by the term. So operators are required to exercise due diligence, and to that end, they shall use a framework of procedures and measures. And they say that the system should be documented in a step-by-step method aimed at producing a consistent and a desired outcome in a business process. So I think what we take from that is it does need to be systematized and written down. It can't, be something that's in someone's head. And so when we talk about due diligence, we talk about 4 steps. So the regulation itself, it requires you to have certain access to information. It requires you to do a risk assessment. It requires you to mitigate wherever there is risk, and that's explicitly written in the regulation. The sort of quality management aspect of a due diligence system is that kind of the overarching requirement that governs those other 3 activities. And when we look at the enforcement actions in later slides, the failure to have an adequate due diligence system that covers all aspects of the regulation and is implemented is the most common reason for a remedial action or a penalty. It's very difficult to prove that something is illegally harvested and placed on the market. It is much easier to show that the due diligence system wasn't compliant with the UTR. And it's also easier to demonstrate when maybe the due diligence system is compliant, so you've hit all the right boxes, but is it implemented? And the implementation is, have you got the information? Have you risk assessed? And wherever there is risk, have you mitigated? So all 4 steps are really important. So what should a quality management system include? Well, there needs to be a solid commitment from the organisation, ideally endorsed at a higher level, and we always encourage policies related to such things to be made public. There needs to be clear responsibilities within staff, and the staff need to be trained and have the competence to fulfill those responsibilities. A quality management system has to include documented procedures, and there needs to be regular quality controls and reviews of that system to identify where it's perhaps not working properly. I think the easiest thing in a quality management system is creating the system. I think that the much harder thing is the implementation of the system. So that last point is really important. This diagram really is just to highlight those 4 steps. With the access to information, risk assessment, risk mitigation, it's not a linear process. You don't do one, then the other, then the other. They're all connected, and there's a feedback loop there. So it's easy for us to talk about them as a kind of stepwise distinct processes, but really they all happen kind of one and the same. Just to say on that, the best due diligence systems are bringing risk mitigation kind of upfront in the process, and anticipating the risks before placing products on the market. Right, now I'm going to move on to definitions of legal and illegal timber within the context of the regulations. It's important you understand the definitions around legality, because without this, you're not going to be able to effectively risk assess against that definition. Your risk assessment might end up being a narrower assessment of risk than the regulation requires you to do. So this is from text from the regulation. So and it describes legal timber as in the absence of an internationally agreed definition of legal timber, the legislation of the country of harvest, including regulations, including relevant international conventions to which the country is party to, should form the basis of a definition of legal timber. So the regulation, the ETR, the UKTR, refers to applicable legislation in the country of harvest. That's a fairly vague term, but the EC has issued guidance and an explanation as to what applicable legislation means. And I think sometimes seeing that definition and what that is broken down into can surprise some people in terms of the scope of regulations that's included there, because it's not just the physical harvesting of the material or the trees. So it's rights to harvest timber within the gazetted boundaries, payments of harvest rights and duties when timber harvesting. It includes environmental and forest legislation, including forest management, biodiversity conservation when directly related to timber harvesting. It also includes third-party legal rights. And finally, it covers trade and customs insofar as the forest sector is concerned in the country of harvest. Yeah, I think that covers everything. All right, I'm going to move on to definitions of risk. So you're required by the regulation to do a risk assessment. But what are you risk assessing? So taking that definition of legality, that then prompts you to, you're assessing risk at a forest level, but because of that trade and customs definition of legality there at the bottom, you also need to be looking at risk in the supply chain relating to trade and transport in the country of harvest. So, you know, if there are many nodes in the supply chain within the country of harvest, you need to be looking at all of those up until the point of export. And then finally, there's the risk of mixing. So when you read the regulation, it talks about the supply chain complexities and the risk of contamination with unknown material, because unknown material is a risk in itself, whether or not that material is illegal. Because if it's unknown, that means you can't fulfill the information requirements and you can't do the risk assessment. Or risk of contamination with illegal material. And the risk of mixing is probably the bit people do struggle with, and sometimes it's overlooked. So when we talk about risk and risk assessment conclusions, the risk is never absent, but it can be low. The regulations talk in terms of negligible and non-negligible risks, so this sort of strange terms that it sort of, it either exists or it doesn't, and there's no middle risk. So if you identify risk, then you have to address it. It is sort of green or red, there's no orange. And what constitutes risk is not clearly defined. So I'm going to finish this presentation with a look at enforcement activities. So operators are liable to prosecution and can receive penalties under the regulation, can be fines, be seizures and confiscation of products, and it could, although it hasn't to date, lead to imprisonment, directors, and the suspension of trade permits. We see fines and seizures being more regular sanctions imposed. So to some degree, enforcement across the EU is a little bit inconsistent in terms of what the competent authorities are looking for in their approaches and interpretations of the regulations. It can differ, but overall we're seeing an increasing alignment across competent authorities through various kind of programs at EU level to bring them together. There isn't a like solid sort of data set on enforcement cases, but there is reporting done by competent authorities which are gathered by the WCMC, and you can find those reports in the links below, the second link there in the list. And I think what's really useful about the enforcement cases we do know about is you can learn quite a bit about the types of infractions that competent authorities are picking up on. For example, approaches to certified material and things like that. So it is really useful to see. Down there, there's just various other links for you to look at in your own time around enforcement. And there have been a number of prosecutions across several countries. There's been a number in the UK, Denmark, Germany, France. Some of the higher kind of profile cases have centered around tropical hardwoods from Brazil, teak being imported from Myanmar, and also timber from Central African countries. And that final point there is something I've already covered, really, is just to say the vast majority of these prosecutions or cases relate to weaknesses in the due diligence system or the failure to apply the due diligence system, rather than the material being successfully proved to be illegal.